Occupational accidents and the burden of proof. In a recent judgment, the Court of Appeal of Ancona, 15th of July 2022, number 189, held that the burden of proving the existence of an injury and the harmfulness of the work environment, as well as the connection between the two, is on the employee who claims to have suffered damage to their health as a result of their work activity. The employer has the burden of proving that it took all the necessary precautions to prevent the injury from occurring, or that it is not attributable to the breach of its obligations. This is the case whether one classifies the claim in terms of contractual liability under Article 2087 of the Civil Code, or if the breach of the principle of neminem ladere under Article 2043 of the Civil Code is alleged. In its assessment of the case, the Court of Ancona held that the appellant had not provided sufficient proof, the burden of which fell on them, of the existence of specific omissions on the part of the employer in the preparation of safety measures suggested by the particular nature of the work, experience, and techniques necessary to avoid the injury that were required from the safety standards suggested by knowledge at the time and by regular adoption in the sector. In particular, they observed that the manner in which the accident occurred had not been proven in historical factual dimension. The ascertainment of the exact dynamics of the accident in this case was of decisive importance in establishing the exact fulfillment of the employer's obligation of safety, since Article 2087 of the Civil Code does not configure a hypothesis of objective responsibility as specified by various rulings of the Court of Cassation. The lack of evidence in the case at hand was due to the fact that the appellant had belatedly, only at the first hearing of the first instance proceedings, submitted its preliminary inquiries concerning the dynamics of the accident. In particular, the court specified that the company's proposal for an amicable settlement of the dispute, not accepted by the employee, was aimed exclusively at avoiding the risk and costs of ascertaining the facts in court, and for this reason, no confessional connotation could be attributed to that proposal. This implies that the worker could not have any protectable expectation in favour of the existence of an admission of liability by the company regarding the dynamics of the accident, which the appellant therefore had the burden of proving in court after formulating relevant and timely preliminary inquiries within the terms and according to the procedures set forth in Article 414.5 of the Code of Civil Procedure. Anna Minutolo, lawyer.